for the state and the defendant. Members of the jury, all the evidence has been presented. It is now your duty to decide from this evidence what the facts are. You must then apply the law which I'm about to give you to those facts. It is absolutely necessary that you understand and apply the law as I give it to you and not as you think it is or as you might like for it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied to him or her. In this case, the attorneys for the state and the defendant have made opening statements. The purpose of an opening statement is narrow and limited. It is an outline of what the attorney believes the competent and admissible evidence will be. Opening statements are not evidence, and you must not consider them as evidence. The evidence came in the form of the testimony of the witnesses, admissions of the parties, stipulations of counsel, or any physical exhibits that were offered by the parties. You must disregard any statement that an attorney made in their opening statement that was not supported by the evidence that was admitted in this trial, and you must not consider it in any way in your deliberations. The attorneys have also made final statements or arguments. The final arguments of the attorneys are not evidence, but they are given to assist you in evaluating the evidence. Your duty is to decide the facts from the evidence. You and you alone determine what the facts are in this case. If an attorney attempted to restate a portion of the evidence and your recollection of the evidence differs from that of the attorney, you are to be guided by your recollection. In my discretion, I have allowed you to take notes during the course of this trial. When you begin your deliberations, you may use your notes to help refresh your memory as to what was said in court. I caution you, however, not to give your notes or the notes of any of the other jurors undue significance. Any notes taken by you are not to be considered evidence in this case. Your notes are not an official transcript of the trial. For that reason, you must remember that in your jury deliberations, notes are not entitled to any greater weight than the individual recollections of the other jurors. The defendant has entered a plea of not guilty. The fact that the defendant has been indicted is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed to be innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence that has been presented, or lack or insufficiency of the evidence as the case may be. Proof beyond a reasonable doubt is proof that fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the credibility, that is the believability of each witness. You must decide for yourselves whether to believe the testimony of any witness. You may believe all or any part or none of what a witness has said on the stand. In determining whether to believe any witness, you should apply the same tests of truthfulness which you apply in your everyday affairs. These tests may include, among other things, the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which he or she testified, the manner and appearance of the witness, any interest, bias, or prejudice that the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable and whether the testimony is consistent with other believable evidence in the case. Excuse me. You are the sole judges of the weight to be given to any evidence. And by this I mean, if you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all the other believable evidence in the case. The defendant in this case has not testified. The law gives the defendant this privilege. This same law also assures the defendant that the decision not to testify creates no presumption against the defendant. Therefore, the silence of the defendant is not to influence your decision in any way. There are two types of evidence from which you may find the truth as to the facts of a case: direct and circumstantial evidence. Direct evidence is the testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain or group of facts and circumstances indicating the guilt or innocence of a defendant. The law makes no distinction between the weight to be given to either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all of the evidence in this case, and after weighing all the evidence, if you're not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. Proof of motive for the crime is permissible and often valuable, but never essential for a conviction. If you are convinced beyond a reasonable doubt that the defendant committed the crime, the presence or absence of a motive is immaterial. Motive may be shown by facts surrounding the act if they support a reasonable inference of motive. When thus provided, motive becomes a circumstance to be considered by you. The absence of motive is equally a circumstance to be considered on the side of innocence. Evidence has been received tending to show that Nancy Cooper made statements to various witnesses regarding the status of her relationship with the defendant, Bradley Cooper. This evidence was received solely for the purpose of showing Nancy Cooper's then existing mental, emotional, or physical condition. If you believe this evidence, you may consider it, but only for the limited purpose for which it was received. You may find that a witness is interested in the outcome of this trial. In deciding whether or not to believe such a witness, you may take the witness's interest into account. If after doing so you believe the testimony in whole or in part, you should treat what you believe the same as any other believable evidence in the case. Photographs, diagrams, and maps were introduced into evidence in this case for the purpose of illustrating and explaining the testimony of a witness or witnesses. These photographs, diagrams, and maps may not be considered for you by any other purpose. Photographs and videos and diagrams were also introduced into evidence as substantive evidence. These photographs and videos may be considered by you as evidence of facts they illustrate or show. I instruct you that the state has the burden of proving the identity of the defendant as the perpetrator of the crime charged beyond a reasonable doubt. This means that you, the jury, must be satisfied beyond a reasonable doubt that the defendant was the perpetrator of the crime charged before you may return a verdict of guilty. In this case, you have heard evidence from witnesses who have testified as expert witnesses. An expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have specialized skill or knowledge. As I have instructed you, you are the sole judges of the credibility of each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to the other tests of credibility and weight, the witness's training, qualifications, and experience or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, and whether the opinion is reasonable, and whether it is consistent with the other believable evidence in the case. You should consider the opinion of an expert witness, but you are not bound by it. In other words, you're not required to accept an expert witness's opinion to the exclusion of the facts and circumstances disclosed by other testimony. When evidence has been received from a witness in the form of an opinion, you may only consider the opinion of a witness which is rationally based upon the perception of the witness and helpful to a clear understanding of the witness's testimony or to the determination of a fact and issue. When evidence has been received tending to show that at an earlier time a witness made a statement which may be consistent with or conflict with his or her testimony at this trial, you must not consider such earlier statement as evidence of the truth of what was said at that earlier time, because it was not made under oath at this trial. If you believe that such an earlier statement was made, and that it is consistent with or does conflict with the testimony of the witness at this trial, then you may consider this, together with all the other facts and circumstances bearing upon the witness's truthfulness, in deciding whether you will believe or disbelieve the witness's testimony the witness's testimony at this trial. The state contends, and the state